The Socio-Economic Rights and Accountability Project, SERAP, has called on President Bola Tinubu to direct the Minister of Communications, Innovation and Digital Economy, Bosun Tijani, to withdraw the lawful interception of communications regulations 2019. Now, SERAP describes the regulations as unconstitutional and unlawful, warning that they undermine Nigeria's obligations under international human rights law. Now, the group insists the rules pose serious risks to privacy rights and civil liberties. Now, the regulations introduced in 2019 empower authorities to intercept and monitor communications. SERAP's argument is that such powers lack adequate safeguards and could be abused to silence dissent and restrict freedoms. In a statement, SERAP urged the government to prioritize reforms that protect citizens' rights rather than expand surveillance measures. It emphasized that Nigeria must align its digital policies with constitutional guarantees, while the call adds to growing debates over surveillance and data privacy in Nigeria.
Well, to provide more insight into SERAP's call on the President to direct the Minister of Communication, Innovation and Digital Economy to withdraw the lawful interception of communications regulations of 2019, we're joined by Kolawole Oluwadare. He's the Deputy Director of the Socio-Economic Rights and Accountability Project, otherwise known as SERAP. Thank you for being here.
Yeah, thank you for having me.
I mean, let's begin from the obvious question. This was a 2019 enactment, a law. Why now? Why now?
And why now? Perhaps because the case of the former Kaduna State Governor brings this to light. And I can assure you, even though we don't have the facts, that perhaps this regulation has been used over time to intercept communications between people. And again, that points to the flaw in this kind of regulation. The fact that we do not know how it is being used, records of how it's been used, or perhaps abused, is one of the things that we need to talk about. But right now, because the former governor is talking about it, Nigerians are talking about it. So it's a good thing that has come out from the baton, if you ask me.
Interesting point there. Well, I mean, SERAP, your group, says, and I quote, any restriction on the right to privacy must strictly comply with the principles of legality, necessity, and proportionality. Well, you say the regulations fail on all three fronts. In what sense, really? Because I'm looking at the necessity aspect of it. For a country that's facing, an existential problem like terrorism, banditry, and all manner of, crimes, non-state actors taking up arms against the nation, don't you think the issue of necessity does apply here? There's a need to intercept, calls.
Yes.
And communications.
It might be necessary to intercept, and the regulations are necessary. But the wordings and the use of the law is not necessary in this instance. So when we talk about necessity, we're talking about these particular regulations, the wordings of that laws, the provision is made, civil liberties, safeguards, and then the propensity for misuse and the misuse itself. And that is in that very fact, we find that it's not necessary. Can we ask, for instance, how far has the DSS or the Office of the National Security Advisor used this regulation to fight terrorism? We do not know. For all we know, and this is a guess, I do not know, perhaps this is used against civilians. This might be used against people that they perceive as being critical of government. And that is why when regulations like these are made, and we believe that this shouldn't be made by way of regulation, by the way, this should be substantive law. Not because the NCC cannot make regulations, but when you look at the kind of weight, the power that this kind of regulation has, why can't it go through the whole log of legislative process, public hearing and the likes? This regulation has the power to take away major rights that Nigerians have. Why can't it go through the real legislative process that will build in those safeguards to make it necessary and effective to fight insecurity?
Is your position that Nigeria should not have this interception framework, or that it should be modeled on jurisdictions like we have in South Africa, like we have in the United States and United Kingdom, because it's done around the world?
Yes, and that's the exact point I'm making. We need to have these kind of safeguards. Even the NCC Act itself has provided for these kind of things in Section 146 and 147. But when you see the way we've made these regulations and the content of it becomes more dangerous the way it can be used. A very good example is the way, who are the authorized agencies under the regulation that can lawfully intercept? There is a lot of conflict. Section 4 talks about the Office of the National Security Advisor and the DSS. Then the interpretation section in Section 23 mentions a whole lot of organizations, including the NDLE, the EFCC, and the Nigerian police. So who are the authorities that can't really use these things. Another good example would be, what are the oversight mechanisms or the agency institution that would oversee the use of this? Guess what it is? The Office of the Attorney General of the Federation, who at best is a political appointee. So it means that who oversees the use or the misuse of this kind of powerful tool is a political appointee who is seen as more of a personal lawyer, as it were, to the president, and not a defender of the people. So you can see the inherent misuse that would occur with this kind of regulations.
Ideally, who should, be at the forefront of ensuring or guarding this? And what are some of these safeguards that you talk about?
And that's why I mentioned, for instance, if it had gone through the legislative process of a substantive law, perhaps an institution will be created that will be free from the details of politics, given how we politicize nearly everything in Nigeria, that can effectively oversight the use of these kind of regulations. But when you look at the agencies, for instance, authorized by that law in Section 12, we have the Office of the Nigerian Security Advisor and the DSS, who more often than not, the NSA is a political appointee. Right. DSS is more of an institution. And so we need an independent institution that can cross-check and oversight.
But what's the guarantee that this independent institution you talk about?
But at least the ones we have now,
that's creating another institution.
But the ones we have now are not really independent,
yeah,
so it's
there
problematic.
Are no guarantees on that.
And that is why perhaps it should go through the courts.
What are the safeguards that you think will protect the Nigerian from undue surveillance?
And one of them will be that to make sure that the use of that lawful intercept by use of a warrant should go to the courts. As it's why in the regulation, there's a provision that says that it must be with a warrant. And then there's another provision that says you can do without a warrant, all because it's of national security. And national security is not defined in the regulation. So it means the regulation gives the judiciary the power, oversight powers, and takes it away with another hand. That is not good enough, not at all.
Okay, I mean, is this about striking the balance between liberty and security, or the fundamental issue that cuts across all sectors in Nigeria when we are having national debates, the issue of trust? One wonders, is it that the institutions that we have at the moment, as you have cited, they're not trustworthy enough? Because when you keep reiterating they are the appointments of the president, they are appointees of the president rather, it does look like you're raising the issue of trust when it comes to oversighting. But then again, like Ngozi has highlighted, there are so many reasons why this could be done. But I wanted to ask you, you have demanded for the president to ask the minister to withdraw this. Should that not be done, what next? And many Nigerians see SERAP as one in the forefront of all this accountability demands. I mean, we've lost count of the cases you have in court. Some wonder, how far really do you go with all these cases? Is it just about instituting them? Are there real changes when you institute these cases? And in this particular instance, should the president not heed your call, then are you going to court again?
Unfortunately, we would have to go to. And why would we do that? Because the law empowers us to do so. What's the alternative? If the president, for instance, decided to breach the law, we can only go to court, because the Constitution empowers us as citizens to go to court to ventilate our grievances and to get the court to side on the part of the Nigerian people in this instance. So I really do hope the president will do the right thing. Because what we're asking is very simple. Withdraw these regulations to the Minister of Communications and make a law that will go to the legislative processes that would have those civil liberty safeguards. There can be lawful intercept, but there will be guardrails that will ensure that it's not misused. That's all we're asking. And I see no reason why the president won't do that. And I also don't see any reason, if you go to court, why the courts will not side with Nigerian people. The judge, if you go to court, is a Nigerian. His phone, or our phone, is also subject to this kind of things. So really, we do not want to go to court. We might have to go to court. And if we do go to court, I can assure you we'll have a win.
How many wins have you had so far?
Presently, we have more than 17 judgments against the government. Positive ones. Yeah.
Interesting. Great. That's interesting to note. Kolawole Oluwadare is the Deputy Director of Socio-Economic Rights and Accountability Project at SERAP. Of course, SERAP is already a household name in Nigeria. Thank you so much for joining us, and thank you for your work.